Yes, I can hear you loud and clear. Can you hear me? Okay, all right. I'm going to transfer the call into you in another 2 minutes or so. All right, bye.
Good morning and a warm welcome to you all. I'm Secretary General, Excellencies, colleagues. We're very grateful to the co-organizers, Argentina, Australia, France, Mongolia, and indeed Italy, which helped contribute to the funding to this, to help pay for this event. The latest General Assembly resolution of last December on the death penalty added to the regular call for a moratorium on executions by putting a new emphasis on a new element of transparency, including making publicly available information on scheduled executions and by following transparent clemency procedures. As the number of countries practicing executions is mercifully declining, nevertheless, some of those countries that still retain the death penalty seem to be even more determined to hide what they're doing, and even to the extent of hiding the locations of where the bodies of executed prisoners are buried, which seems a needlessly cruel additional punishment for the families. But based on the principle that transparency is the sort of surest safeguard of fairness, the purpose of today's meeting is to focus on three aspects of transparency. One, transparency over evidence, because some countries withhold evidence from the defense and from the prisoners themselves. And today we have a chief counsel of one of the defendants at Guantanamo to speak about that. Secondly, transparency for the families, allowing them to know about the whereabouts and conditions of their loved ones. And thirdly, information on data, including on the number of executions. So first we'll hear from the Secretary General, then we will hear from the co-sponsors, then the panelists, then we'll have an open discussion, and after which there will be a Facebook Live event. Secretary General, it's a great honor for us to have you with us. The floor is yours, sir.
Well, thank you very much, Excellencies, distinguished panelists, ladies and gentlemen. I must apologize because I'm going to do something that I consider totally unacceptable from the perspective of someone that tries to be polite, which is I'm going to speak and then I will not be able to listen to the interventions of all the sponsors and panelists. But unfortunately, in this crazy merry-go-round that is my life at the present time, I will not be able to stay after 10:30. So my apologies. It's a very rude behavior, but I have no alternative. I thank the Office of the High Commissioner for Human Rights and the Member States who have co-sponsored this important event. And we are here to explore a very urgent and troubling human rights issue, the continued use of the death penalty and the secrecy that surrounds it. This is my first public statement as Secretary General on the death penalty. And I want to make a plea to all states that continue this barbaric practice. Please stop the executions. The death penalty has no place in the 21st century. I'm proud to say that my country, Portugal, abolished capital punishment 150 years ago, one of the first countries to do so. As a matter of fact, I was told in school that we were the first country, but I don't want to create eventually any incident with any other country that must claim that. This is indeed something I'm very proud of. And the reasons were those that we call on today. The death penalty does little to serve victims or deter crime. And even with meticulous respect for fair trials, there will always be a risk of miscarriage of justice. This is an unacceptably high price. So, Excellencies, ladies and gentlemen, the world is now moving in the right direction, even if slowly. Ever more countries are abolishing the death penalty and establishing moratoria on its use. Some 170 states have either abolished it or stopped using it. Just last month, 2 African states, the Gambia and Madagascar, took major steps towards irreversible abolition of the death penalty. I welcome these developments and congratulate both governments for their principled stance. In 2016, executions worldwide were down 37% from 2015. And today, just 4 countries are responsible for 87% of all recorded executions. But at the same time, we are concerned by the trend of reversing long-standing moratoria on the death penalty in cases related to terrorism. And those countries that do continue executions also have international obligations. In many cases, they are failing to meet them. Transparency is a prerequisite to assess whether the death penalty is being carried out in compliance with international human rights standards. It also honors the right of all people to know where their family members are alive or dead and the location of their remains. But some governments, as it was said, conceal executions and enforce an elaborate system of secrecy to hide who is on death row and why. Others classify information on the death penalty as a state secret, making its release an act of treason. Some limit the information that can be shared with the defense lawyers, limiting their ability to appeal for clemency. And still others grant anonymity to companies who provide the drugs used in executions to shield them from negative publicity. This lack of transparency shows a lack of respect for the human rights of those sentenced to death and to their families. It also damages the administration of justice more generally. Full and accurate data is vital to policymakers, civil society, and the general public. And it is fundamental to the debate around the death penalty and its impact. Secrecy around executions undermines that debate and obstructs efforts to safeguard the right to life. Today, on the World Day Against the Death Penalty, I reaffirm my opposition to the death penalty in all circumstances. And I invite all those states that have abolished the death penalty to support our call on the leaders of those that retain it to establish an official moratorium with a view to abolition as soon as possible. I wish you a successful and thought-provoking discussion, and I thank you very much.
Thank you, Secretary General. I give the floor to the Ambassador of France.
Merci Andrew. Monsieur le Secrétaire Général, Madame et Messieurs les ambassadeurs, mes chers amis, I'd like to start by thanking the Secretary General for his presence among us and his inspiring intervention on an issue which is dear to my country, which is really dear to France. Universal abolition of the death penalty, whatever the circumstances, has become a pillar of our diplomacy. It is very much part of our DNA. It is also, should I say, a marque de fabrique, a trademark, a specificity of the European Union in which no one can access or remain if it has not abolished this inhuman punishment. We are honored to have strong and reliable partners from all the continents who share our goals and efforts towards abolition. I want to thank all participants present here this morning. Together, we have come a long way since 2007, and we have made important achievements within the UN. 10 years ago, the General Assembly adopted its first resolution calling upon the establishment of a moratorium on executions with a view to abolishing the death penalty. 3 days were necessary to vote on all amendments and motions presented to defeat this text. Since then, the resolutions has benefited from growing support, always with more votes in favor and less votes opposed to it. The UN now has a policy that excludes cooperation with member states when there is a risk that the death penalty could be used. Since the establishment of the International Tribunal for Yugoslavia in 1993, all international tribunals have excluded death penalty from their statutes. All this reflects, I would say, an emerging consensus towards the end of death penalty. Beyond the UN, the opposition to death penalty has gained ground in a large part of the world, with a number of countries shifting to abolition. We welcome the decision taken in this regard by Mongolia, congratulations, dear Saki, Gambia, Benin, Nauru, and Guinea. Still, our progress should not be taken for granted, and we have to be extremely vigilant. These achievements, indeed, are not irreversible. In an uncertain world, temptations to re-establish the death penalty, to give confidence to public opinions worried by their safety, does exist. All our societies are concerned. Some countries are moving a step forward, or backward, should I say, and are considering resuming executions and breaking moratoriums, among them Nigeria, Bahrain, Kuwait, or Jordan. Death penalty is still used in significant parts of the world, notably in China, Iran, Saudi Arabia, Pakistan, Iraq, and the United States. Thanks to the discussions that are taking place on this symbolic day all over the world, we can keep the momentum. Transparency is the theme of our discussion today. Why is it so important? Because our societies need to have informed debates to decide what is desirable with regard to abolition of the death penalty, based on values, but also based on facts. In some countries, it is impossible to even know the number of executions or condemnations of the crimes people have been convicted for. How can one challenge the so-called deterrent effect of capital punishment without this basic information? We also owe transparency to the convicted whose basic rights cannot be guaranteed in secrecy and their family. The reasoning behind the death sentence, the procedure for appeal, pardon, or commutation are important safeguards in fair proceedings. For those waiting years on death row, doesn't this amount to a form of cruel, inhuman, or degrading treatment or punishment? The release of information is, of course, the primary responsibility of the states that apply the death penalty. But when this data is not provided, when this data is provided, then the international human rights system, including the United Nations and regional mechanisms, may have a role to play in gathering and sharing information. We must maintain a united front together with the NGOs, such as Amnesty International or Ensemble contre la peine de mort, who do great advocacy work throughout the world, as borne out by the evidence and information gathered on the ground. You know, my friends, I don't want to lecture anybody here. If you think about it, it took France 2 centuries to get rid of the death penalty before it was first abolished in 1795. When it was eventually abolished for good in October 1981, 36 years ago, death penalty has been sentenced 8 times during that year. Death penalty was, as you can see, deeply rooted. Our European partners were key in convincing our leaders, our population, our media, our judiciary, that this sentence could not be right. That is why France strongly believes in the value of international efforts and partnerships. We have to work hand in hand to fill in the information gaps and to fuel the debate, keeping in mind one single goal: to put an end to this irreversible, inefficient, and inhumane punishment in the world. I thank you.
Thank you for those powerful words. I know you now have to preside over the Security Council, but thank you so much for coming. The Ambassador of Australia.
Thank you very much, Andrew, and thank you to OHCHR for organising this event, and thank you very much, Secretary General, for attending and speaking out on this issue. Colleagues, ladies and gentlemen, this year marks 50 years since Australia carried out its last execution. Australia is committed to abolition and welcomes the growing trend towards a death penalty-free world. However, it is an unfortunate fact that the death penalty is alive and well around the world, including in our region, the Asia-Pacific. While all but 2 states in the Pacific region have abolished capital punishment, most of our neighbours in Asia retain the death penalty, either in law or practice. Mongolia is a recent welcome exception to this trend. And too many of these states are active executors. A lack of transparency in states' use of the death penalty is a particular problem in our region, where the vast majority of executions are conducted behind a thick veil of secrecy. This secrecy has profound effects at many levels. When an accused has no or little notice of their execution, the crushing weight of anticipation and uncertainty can be tortuous. When a family does not receive notice or adequate notice of a relative's execution, the harm can irreversibly affect parents, children, partners, friends, and colleagues. These people are entirely innocent and do not deserve such treatment. When a community is not aware of the scale and nature of the deaths imposed in its name, it is so much more difficult to gauge and reflect public attitudes. When a state seeks to obscure or conceal the number and means of executions, it risks very grave breaches of the human rights of those facing the death penalty. By casting a light on the practice, transparency can prevent wrongful executions, decrease discriminatory application of the death penalty, and stop cruel methods of execution. Ultimately, it can help a state to realise that the death penalty is not a solution to crime. We seek the global abolition of the death penalty sooner rather than later. However, for some states, the path to abolition will be long and difficult, and Australia encourages any steps that protect the human rights of those facing the death penalty. Transparency is a welcome first step. Thank you.
Thank you for underlining the human costs of the lack of transparency. Ambassador of Argentina.
Thank you so much, and Excellencies, distinguished guests, ladies and gentlemen. Let me begin expressing our deep appreciation to the Secretary General for his presence today as a way of showing the continuous commitment of his office to this important, very important human rights issue. I would also like to acknowledge the message of the President of the International Commission against the death penalty and express our gratitude for the work that the Commission is carrying out in raising awareness of the appalling consequences of the use of the death penalty and on the need to make steps towards its abolition. For Argentina, it's an honor to co-sponsor this side event in order to discuss the importance of increasing transparency in the use of the death penalty, including by making publicly available information on scheduled executions and by following fair and transparent clemency procedures. Last year, we had the honor of co-facilitating together with Mongolia General Assembly Resolution 71/187, which focuses on encouraging and supporting moratoriums on executions in countries across the globe. In the said resolution, the General Assembly acknowledged the importance of the moratorium as a tool for allowing retentionist countries and to hold domestic and regional discussions and debates on its use. The access to reliable and appropriate data is essential for the people directly affected, but also for policymakers, civil society, and the public in general in order to hold informed debates and decisions. We are glad that Resolution 71/187 made a strong call for governments to make available relevant disaggregated data, as well as information on the number of persons sentenced to death, the number of persons on death row, and the number of executions carried out, the number of death sentences reversed or commuted, on appeal, and information on any scheduled execution. We hope that in the near future this call is properly heard by all concerned states. From our point of view, it is evident that the guarantee of due process and the right to defense, among other safeguards linked to transparency and access to information, should be the cornerstone of any criminal system. Those of us committed to the abolition of the death penalty must continue working on creating consensus on minimum standards to ensure the protection and respect of human rights of all. Therefore, I'm glad to mention that during the high-level week, together with Mongolia and the European Union, we presented the Global Alliance to End Trading Goods Used for Capital Punishment and Torture, which has been joined already by 59 member states. Argentina is convinced that ending trade of products used for death penalty or torture is a very powerful tool to eradicate torture and to achieve a global moratorium on the use of the death penalty. Torture and capital punishment have proven to be no deterrent for crime. Immediate and concrete action is needed, and this global alliance is a first step in the right direction. To finalize, please let me thank the Office of the High Commissioner for giving us the opportunity of discussing in the context of the United Nations the issue of transparency and death penalty, allowing us to bring different perspectives to complement the language of the General Assembly resolution. Thank you so much.
Thank you, and thank you for referring to the Global Alliance and that meeting you co-organized. I was honored to speak at it. It's a grotesque trade, the idea that people are commercially selling and with sort of mail-order catalogs for weapons of torture and execution. Thank you. Ambassador of Mongolia.
Thank you, Mr. Secretary General, for your presence today here, and it's also my pleasure to welcome all of you to today's panel discussion. Today we are witnessing the global trend away from capital punishment as more and more member states from across all parts of the world acknowledge that the use of death penalty undermines human dignity and that abolish or at least a moratorium on its use of a moratorium contributes to the enhancement and progressive development of human rights. Mongolia is firmly committed to protecting human rights, the abolition of death penalty, and fight against torture and inhuman degrading treatment. My country abolished death penalty in 2015 by adopting a new criminal code without any reference to capital punishment and ratified the second optional protocol to the International Covenant on Civil and Political Rights in 2012. Today's discussion is an important event in making available relevant information disaggregated by sex, age, and race as applicable and other applicable criteria with regards to their use of death penalty. Transparency in death penalty in all countries, it's a crucial step towards total abolishment of death penalty worldwide. Death penalty should not be hidden. I thank you.
Thank you, Ambassador. We are really happy to have Mongolia with us today. We're also very grateful for the consistent support that Italy has always given to OHCHR on our death penalty activities. The floor is yours, ma'am.
Thank you. Mr. Secretary General, Excellencies, ladies and gentlemen, we are very pleased today to co-host this important panel discussion on transparency and the death penalty. For many years, Italy has proudly been at the forefront of several initiatives concerning the death penalty, being firmly convinced that capital punishment is not a deterrent for crime. The international campaign on the universal moratorium of the death penalty has been a top priority of our foreign policies since the 1990s, and it is deeply felt also among our civil society. Moreover, during the last years, Italy has been at the side of the Secretary General and of the Office of the High Commissioner for Human Rights in supporting their work on the death penalty, including important awareness-raising and discussion events like this one on the most crucial aspects of the issue. Transparency deficits are undoubtedly among them. While welcoming clear progress and many encouraging signs, including a high number of abolitionist countries, the lack of transparency on the use of the death penalty worldwide continues to be of great concern. First of all, the lack of transparency in some criminal justice systems and on data concerning death sentences makes it impossible to confirm any credible figures. Second, transparency also plays a critical role in relation to the implementation of the safeguards, guaranteeing protection of the human rights of those facing capital punishment. As also just highlighted by the Secretary General, the implementation of the death penalty without the requisite of transparency makes it difficult, if not impossible, to assess whether it is being carried out in compliance with international human rights standards. For these reasons, we strongly support the Secretary General's call on all states to maintain the death penalty to systematically provide full and accurate information on death sentences, including disaggregated data on gender, age, nationality, ethnic origin, and other relevant demographics of the persons affected. The last resolution of the moratorium of the use of the death penalty adopted by the General Assembly last December with a strong cross-regional support is a particularly important instrument in this regard. Not only does it unequivocally frame the death penalty as a global human rights concern, but it also strongly calls on all states to increase the transparency in the use of the death penalty, including by making publicly available information on any scheduled executions. While continuing to strongly advocate for the universal moratorium of the capital punishment, since the very outset of the launch of the international campaign, we have been deeply convinced that this objective can only be achieved through dialogue and mutual understanding among all member states, in accordance with the Charter of the United Nations. In this spirit, we firmly believe that increased transparency surrounding numbers and procedures would allow a considerable enhancement of the debate around capital punishment. I thank you.
Thank you very much, Secretary. Now, assuming that it works, thank you, Jessica. Assuming that it works, we will now have a statement from Federico Mayor, who is president of the International Commission Against the Death Penalty. really, we'll cut that. We'll send out the statement. It's very embarrassing. The only silver lining is that the Secretary General left just before that happened. Anyway, so we now have, we will send, I mean, because that's obviously very bad treatment for him. We will ensure that his statement is transcribed and posted. James Connell. We're now going to start with our panelists. The lead defense counsel in the case of United States versus Ammar al-Baluchi in Guantanamo, and who's been held in Guantanamo for 10 years, charged with war crimes, which carries the death penalty. We'd like to hear first from you, sir. And then I will ask, what we'll do, I will introduce the four panelists by name and then have 2 or 3 questions to each of them.
Thank you to this. Thank you.
Sorry, could we cut the photograph now? Thank you. Sorry, a little off-putting.
Thank you to the Secretary General and Excellencies for your commitment to due process and to the abolition of the death penalty. My name is James Connell from the United States Department of Defense Military Commission's Defense Organization. The existence and funding of such an organization is a testament to the commitment to the right to counsel and to the equality of arms. But today I speak not for the United States government or any agency, but only for my client, Ammar al-Baluchi, who was abducted into a secret CIA prison in 2003 and has been imprisoned at Guantanamo since 2006. These black sites and the torture that was inflicted there have driven U.S. policy regarding transparency ever since. The United States has unfortunately abandoned first principles of transparency in its prisons at Guantanamo Bay. Hard experience has shown that secrecy and confinement is a gateway to the worst abuses, including torture and other forms of cruel, inhuman, and degrading treatment. Despite the consistent requests of the Special Rapporteur on Torture and others, the United States has refused any independent inspection of its prisons at Guantanamo. 6 Muslim men faced death by secretive military commission at Guantanamo, a forum not considered sufficiently fair to try any U.S. citizen. These military commissions are held on a secure military base intentionally located on Cuban soil rather than U.S. soil in an effort to deny these men the protections of the due process of law, including the right to a public trial. The public can only observe trials in the military commissions by a viewing site on one military base, which incidentally also houses the U.S. National Security Agency. Otherwise, the only way to obtain information about what is going on in the Guantanamo Bay military commissions is by Twitter feeds like those of Gitmo Watch or Carol Rosenberg of the Miami Herald. The United States has made extraordinary efforts to hide evidence of the torture of these and other men that it now seeks to execute, even from defense counsel with security clearances at the highest levels granted by the United States government. Although the Senate Select Committee on Intelligence reviewed 6.2 million pages of relevant information for its torture report, the defense in these cases is allowed access to less than 15,000 of those pages. The United States has stripped this 0.25% of relevant information of all dates, locations, witness names, and other critical details. In doing so, the United States has abandoned its responsibilities to transparency and accountability under the Convention Against Torture and the customary international law that it reflects. One recent example illustrates the abuse of transparency, the abuses that lack of transparency brings. The United States, through its prosecution, sought to destroy a site where torture had been used. Attorneys for the tortured men objected and obtained from the Military Commission a public order to preserve evidence of torture, including that black site. While that public order for preservation remained in place, the United States, through its Office of Prosecution, obtained a secret order to secretly destroy the black site, informing attorneys for the defense for the tortured men only after it had gotten rid of the evidence. Critical evidence in this situation was lost forever due to the intentional exploitation of secret processes, demonstrating the critical importance of transparency. Thank you.
Thank you very much, James, and also for coming. Why, in your view, has the US government been so resistant to your right to information? And how would you say this has impacted on the ability to have a fair trial?
The original sin of Guantanamo Bay is the use of torture between the years of 2002 and 2006. Many of the policies which are established at Guantanamo Bay around its lack of transparency, its secretiveness, are essentially, or at their core, an effort to cover up evidence of torture and protect the torturers themselves. That has had an impact on the fairness of criminal trials, which requires, within reasonable limits, both sides to have access to evidence of what happened in the case and the treatment of the defendants and obtaining statements from them.
Would you say that from an international law perspective that the US government has met its obligations under the Convention Against Torture?
The United States has recognized in 2014 the applicability of all Convention Against Torture provisions to all territories under its control, including Guantanamo Bay. But in practice, even after that time, it has enacted the opposite of transparency and accountability. Rather, it has operated with secrecy and impunity for the torturers themselves.
Thank you so much. We actually have a colleague of mine in Bangkok, but I'm so demoralized about the sound system. I'm going to hold it until I'm a little bit more optimistic that we can get. So I'm going to jump to the next speaker, who's Tchérina Jerolon, who's the Africa Desk Director of FIDH. The floor is yours.
Thank you very much. Good morning, ladies and gentlemen. I would like to also thank the Secretary General for his presence and statement, and also the OHCHR for inviting FIDH to participate in that debate. I will obviously focus my intervention on the challenges related to transparency and death penalty in Africa. On April 1st, 2006, Mr. Ping was executed in complete secrecy in Botswana. Nor Mr. Ping's family members nor his lawyer had been officially informed of the date and time of his execution. Instead, they received the information from the radio after the execution was carried out. Mr. Ping's mother had tried to visit her son the day before his execution. Prison officials advised her to come back a couple of days later, while they were actually perfectly aware of the fact that he was going to be executed the day after. After his execution, Mr. Ping's family did not have access to his body. They were not afforded an opportunity to ensure that he received a decent burial, and they did not have the opportunity to visit his grave. Last year, so almost 10 years after Mr. Ping's execution, Mr. Gabakanye was also executed under the same circumstances in Botswana. Those two cases are examples among many others in Botswana and are very illustrative of the secrecy climate that has been surrounding the execution process in the country. Pursuant to Section 18 of the Prison Act, the condemned prisoner is given notice of his execution at least 24 hours before the hanging. But in practice, the secrecy of the post-conviction procedure does not allow for any public knowledge of the exact date of this notice to the prisoner. It is actually generally assumed that the death warrant is transmitted to the death row prisoner only a few hours before his or her execution, and that this information is not provided to the lawyer or to the family. And there is also a complete opaqueness and arbitrariness that surrounds the clemency procedure, which remains really a discretionary power of the executive in this country. When we relocate the situation in Botswana in the broader context of the use and application of the death penalty on the African continent, it becomes very clear that the problematic related to transparency and death penalty is first and foremost politically motivated. More than 70% of African countries have abolished the death penalty in practice or in law, with 10 out of the 55 member states of the African Union executing within the past decade. Congo and Madagascar abolished the death penalty in 2015 and Guinea in 2016. So there is clearly a trend on the African continent toward the abolition of the death penalty. Yet the debate around transparency remains very key and highly contentious. And again, it is usually based on political considerations. If we take the example of Sudan, for instance, the threat of the death penalty really serves as a tool to intimidate or silence political opponents, silence activists, silence harm groups. Authorities regularly use different charges of crimes against the state, waging war against the state, to neutralize their opponents. But this threat does not actually suffer from any lack of transparency. On the contrary, it is claimed as such, it is widely disseminated, and it is used as an affirmation of the state's authority and power over its real or perceived opponents. You might also remember the example in 2012 of the Gambia when the then President Yahya Jammeh made a statement on TV saying that a couple of weeks later, all death row prisoners would be executed. These statements generated a lot of criticism from the international community, yet a couple of days later, 9 death row prisoners were executed, and it was also seen as a way for the president to somehow assert his authority over this process. In most African countries, including in those that did not carry execution, there is an information gap on the number of persons sentenced to death, the number of death sentences reversed or commuted on appeal, the number of instances in which clemency was granted, the number of executions actually carried out. Even in countries that have engaged into the abolition process, there is also a lack of transparency, a lack of public awareness on the same. So generally, we could say that this opaqueness surrounding the application and use of the death penalty on the African continent first reveals authorities' lack of willingness to create space for an informed public debate on the issue of the death penalty. Secondly, it allows states to hold the death penalty process themselves to the exclusion of everyone else. And thirdly, in some instances, it prevents states from admitting their discriminatory use of the death penalty. I just would like to finish by saying that civil society organizations on the continent have attempted to overcome these challenges, and they really play a critical role in breaking the silence. In Botswana, there are a number of organizations, including Ditshwanelo, that have played a major role in trying to generate a public debate on the process in the country. In Sudan as well, you have a couple of organizations working outside the country which have also played a serious role in trying to gather information on the process. So these actions, although they are limited and sometimes very risky for those organizations, would need to be fully supported, and regular and thorough researches are necessary to engage and try to foster the informed debate on this issue.
Thank you very much indeed. Why would you say, what are the reasons for, or rather the avenues for detainees and their lawyers and their families to get greater transparency? And I mean, could litigation be any support? And secondly, do you believe that transparency, calls for transparency could ever resonate with the public in the region you cover, or is it such a feeling that those on death row deserve it, and therefore there's little appetite?
With regard to litigation, for sure, I think that there is actually a need for perhaps further litigation on those cases, especially on the African continent. If we take again the example I gave of Mr. Ping, who was executed 10 years ago, the case was brought to the African Commission on Human and People's Rights, which has a quasi-judicial mandate. The African Commission, since it exists, has rendered almost between 10 and 20 decisions with regard to the death penalty process. But concerning the case of Mr. Ping, it was the first time, and it was due to the work of the litigants, that the Commission had to actually determine whether the secrecy that surrounded the execution of Mr. Ping could amount to acts of torture and cruel and inhuman and degrading treatment. In its decision that it rendered 2 years ago, the Commission took that position that actually Botswana committed acts of torture against Mr. Ping, against his family as well, and ordered the authorities of Botswana to provide compensation to the family and also to revise the legal system. So of course, litigation action can also create some space for further debate on the issue.
You mentioned the African Commission on Human and People's Rights. Do you think there's a role for them, and if so, what could that be?
Well, yeah, there is a role for regional mechanisms. Again, it's a question of creating the space for the debate and generating the space for the debate, especially when we talk about the issue of transparency. The African Commission has taken a major role over the years with regard to the issue of death penalty. They have created a working group on the issue. They have conducted a number of researches. They have organized a number of conferences and so on. And they have also rendered a couple of decisions in terms of litigation aspect. So it's important to try to foster a number of alliances and to ensure, especially in cases of country like Botswana, that the debate is also placed outside the frontiers of the country, and organizations such as the African Commission can create that space for civil society especially.
Thank you very much indeed. There will be time for more questions to all of you later. Cynthia Veliko is our colleague in Bangkok. We have a regional, OHCHR has a regional office there, and we're hoping that we can hear from her now.
Thank you very much. Can you hear me, Andrew?
Yes, we can.
Great. Secretary General, Excellencies, distinguished panelists, ladies and gentlemen, good morning and thank you for this opportunity to present at the Forum on Transparency and the Death Penalty as we collectively commemorate the World Day Against the Death Penalty. My focus for my presentation will be on Southeast Asia. Let me start with the context. In Southeast Asia, Cambodia, Timor-Leste, and the Philippines are fully abolitionist. Of the remaining 8 countries where the death penalty remains in law, Brunei Darussalam, Lao PDR, and Myanmar are abolitionist in practice, and Thailand has not executed anyone since 2009. Although most of the countries in the region have not explicitly supported a moratorium, in 2016 only Malaysia, Singapore, and Brunei Darussalam voted against the General Assembly resolution on the moratorium on the use of the death penalty. In recent years, there have also been some positive developments in the legislation on the death penalty. Singapore removed the mandatory death sentence for certain offenses, while there are ongoing discussions in Malaysia of removing the mandatory death sentence for some drug-related offenses. Thailand has also indicated its intention of conducting a review with the possibility of abolishing the death penalty. Despite this progress, we have also witnessed a number of setbacks in the region with regard to the use of the death penalty. There has been an alarming shift in the Philippines as, despite being a fully abolitionist country since 2006 and also a state party to the Second Optional Protocol to the International Covenant on Civil and Political Rights, the lower house of the Philippines passed a bill in March reimposing the death penalty, predominantly for drug offenses, and the fate of the bill is now with the Senate. We have also seen a rise in a number of executions in some retentionist states over the past years, which include Singapore, Vietnam, and Indonesia. Information provided by Vietnam and Malaysia over the past 2 years have highlighted the previously unknown magnitude of the use of the death penalty, either for sentencing or for actual executions. Mandatory death sentences for certain offenses continue to be imposed in Malaysia and Singapore and are considered inconsistent with human rights law as they don't allow the discretion of judges to take into account the personal circumstances of the case or the particular offense. However, even in countries such as Indonesia, where judges do have that discretion, we are seeing a recent and worrisome trend where there appears to be an increased voluntary use of the death sentence by judges. In Vietnam, the revised penal code adopted in May 2017, that will actually enter into force in January of 2018, retains the death penalty for 18 offenses, including some that are related to drug trafficking and others for embezzlement. Now, if I turn to transparency issues, the lack of transparency surrounding the use of the death penalty in the region remains of grave concern. The minimum requirements of transparency from governments with regard to the death penalty are regrettably often not followed by retentionist states. In certain countries, information on imminent executions or executions that have already taken place are not publicly available. There is also little to no information in some countries on clemency, pardons, and the number of individuals on death row. A lack of reliable information about imminent executions makes it impossible to examine the lawfulness of these cases before the individual's death and to advise a state on its obligations under international law. Making such information publicly available is also an important component in the respect for the broader human rights principle of the right to freedom of information. Lack of information on executed persons or on imminent executions has a profound consequence for individuals and their relatives. In Malaysia and in Singapore, death row inmates and their families are often only given a few days advance notice ahead of scheduled executions. In Vietnam, executions are at times carried out without any advance notice to the family. Serious concerns have been raised about transparency with respect to the independence and impartiality of the judiciary in many of these countries. Data in Vietnam related to the death penalty is by law a state secret, and until just this year there has been no reliable information on the number of executions carried out each year or the number of those that are on death row. The lack of transparency related to data on the number of executions that have taken place or individuals on death row is a serious impediment to international and national debates that could ultimately lead to the abolition of capital punishment. It will also be important for the effectiveness and transparency of such debate to ensure that the public has access to balanced information, including accurate statistics on criminality and global best practices in how to effectively fight crime without resorting to capital punishment. Transparency is crucial in ensuring compliance with international human rights law, including obligations to the right to life, to fair trial, and to freedom of expression and information. As the world moves increasingly towards the abolition of the death penalty, it is all the more incumbent on retentionist states to exercise the highest standards of transparency and to ensure that they fulfill, protect, and uphold their human rights obligations under international law. Thank you very much.
Thank you, Cynthia, for joining us at what is such a late hour where you are. Our fourth and final panelist is Tawanda Mutasah from Amnesty International.
Thank you very much, ASJ Andrew. We also are grateful to His Excellency, the Secretary General, for his remarks and for the leadership that he is showing on this issue. And we thank OHCHR for convening this event and sponsoring states, including appreciating the acknowledgement by France of the efforts that we have been engaged with as Amnesty International on an issue that is close to our work and to our hearts. Since 1977, ladies and gentlemen, as you know, Amnesty started campaigning on this issue when only 16 countries had abolished the death penalty at that stage in law or in practice. And to see where we are today shows that the retention of the death penalty, of this cruel, inhuman, and degrading treatment is untenable, and it shows the progress that we are making. But it's important that we think about the reality of what it means in individual cases when we talk about transparency. So take the case of Abdul Karim al-Awaj in Saudi Arabia, who only at 16 at the time of his arrest, he is now facing the death penalty. Against the international law prohibition on the use of the death penalty for people under 18 at the time of being arrested for the alleged offense. He has had no access to a lawyer during the pre-trial detention period that he has endured and the interrogations that he has endured. He said that he was held incommunicado and in solitary confinement for the first 5 months of his detention. He said that he was tortured, including through beatings, by sticks, by boots, by the prison guards. He was threatened with the death of his family during interrogations by officers of the GDI security to make him sign a confession. According to court documents, he was held without charge for over 2 years. He denies participating in any acts that the prosecution attributes to him. If we didn't have information on this case, as indeed we do not have enough information on it beyond what we have been able to cite here, how would we know about the fairness of the death penalty? How would we know that there is compliance with international law on issues, for instance, such as preferring the death penalty on people that are under the age of 18 at the time that they are arrested? So transparency is key. It is central to the safeguard of due process. It encompasses all aspects of the death penalty, from the different stages of each individual case, such as the case of Abdul Karim that I have recited, right through to the way the death penalty is administered, including how executions are carried out, right through to figures on the use of the death penalty. Transparency around executions is the only way that we can prevent the cruel, inhuman, and degrading treatment that already is built in to the idea of the death penalty itself. Malaysia, for example, we have seen executions continuing to be carried out in a secretive manner, where families are often told, sometimes 2 days before an execution, that an execution is going to be carried out, and they're asked to go to the prison the following day for the last visit. This is not only cruel, but hardly leaves any time to make pleas for clemency against the execution, which could possibly be the reason why this is being done at such short notice. We have also seen countries, we have said in our 2016 statistics and report that 132 people were executed in 2016, but we have added excluding China. How can we, without transparency, be able to see the scale of the use of the death penalty across the world when those statistics are out of view? Transparency is also important at the level of fair trial standards, at the level of the treatment of accused, right through to how the death penalty is preferred against them. We have also seen situations where sometimes the lack of transparency suggests that states have something to hide. Laws on state secrets in China and Vietnam, for example, make it impossible to have figures on the use of the death penalty. However, whenever insights were gained and the veil of secrecy was partially lifted in one way or another, the picture that we gained has been truly shocking. So, for instance, earlier this year, we were surprised to see the amount of executions carried out in Vietnam since it resumed executions 4 years ago, which is actually putting it in the top positions of the list of global executioners. And of course, without transparency, it is impossible to estimate what it is we are talking about in the public sphere, about the role that the death penalty plays. We have said over and over again, and clearly, that the death penalty should be abolished in total, because as Amnesty International, we know and we have seen, speaking to victims, speaking to the families of victims, that the death penalty as an irreversible punishment is irrevocable. We have seen since 1973 how 150 prisoners in the US who had been sent to death row have since been exonerated. If we don't have transparency in statistics, how can those conversations be had? How can conversations about the deterrence of the death penalty and the many other reasons that we oppose it in tort be able to be discussed in the public arena? And it is also important to notice that without access to information on the details of not just executions, but on the details of how even the sourcing of the methods of execution is being carried out, about what we have seen, for instance, in the matter of the secrecy around the sourcing of lethal injections by some states within the United States, about the specific situation of information that goes to individuals, such as Akamada Iwao, released in 2014 in Japan, pending retrial. We're still paying the price for being left for more than 40 years on death row, wondering every day if that day would be his last. It is enough for us to be anxious in this room about whether this event is ending at 12 or at 1. How much more does it mean if you're anxious about whether each day for 40 years is your last? So information and transparency is central. And if the state in this case had been so confident of the fairness of their judicial proceedings to the point of actually wanting to execute somebody, why would they have hesitated? So in conclusion, we would reinforce as Amnesty International that the work that we have continued to do since 1977 that has demonstrated that the death penalty is untenable should now go to that next critical phase where information is transparently available on all dimensions that pertain to the death penalty. I thank you.
Thank you very much indeed, Tawanda. As you alluded, Amnesty for decades has played a pioneering, sustained and very effective role against the death penalty, and we thank you for that. How do you do reports periodically on death penalty? How do you go about that, and what are the main challenges you face?
Yeah, thank you. The Amnesty has a presence, a global presence, and that does help us. And we are able to use our researchers, we're able to speak to families, we're able to speak to victims, we are able to speak to lawyers that are working on cases, we are able to speak to prison guards to see actually the trauma that they experience themselves administering the death penalty. We are able to speak to communities at a variety of levels. But every year, we also send a request of information to states. And unfortunately, we do not always have states providing us with the information that we need. So ultimately, even when Amnesty International and other organizations do what they can to provide transparency and an insight into the reality and practice of the death penalty, it can never be a substitute for the role that states have to play. So using all the capacities that we have in terms of research, collaborating with others, we're able to make the contribution annually that we do. But we would still call upon states to take the responsibility and the obligation to be transparent and to provide information on the death penalty in all aspects thereof.
This is an issue that covers many aspects of human rights, particularly anything to do with prisons. But how do we, and there's a question I asked earlier as well, what could we do more to make the issue of transparency resonate with the public in various countries, particularly, obviously, retentionist ones?
Yeah. It's an important question. I mean, I think at one level, we should actually interpret transparency to also mean that states respond to the obligation and responsibility to discuss with their publics the role that the death penalty is playing in their societies for those states that are retentionist, because it is part of the transparency and the conversation that's needed. At the same time, states should discharge the responsibility to be sharing information with researchers, with NGOs that are working in this area. So, for instance, the work that has been done by the Death Penalty Information Center, which has been remarkable, is informed or has to be informed by the information that states contribute. The work that has been done by the National Law University in India through the Death Penalty Center has to be informed by what states produce. I mean, as OHCHR made a request, for instance, in the last quinquennial report on capital punishment and implementation of the safeguards guaranteeing protection of the rights of those facing the death penalty. On 13 April 2015, only 54 countries provided information to OHCHR. As a very small first step, states should be able to provide this information to OHCHR, to civil society, to their publics, to be able to have a robust discussion on the death penalty.
And obviously relevant to this audience and this building, what more can the UN, what can more can UN member states do to improve transparency? Is this something for the UPR, perhaps?
I think so, and more. The fact that we have had this quintessential milestone of putting the transparency dimension into the discourse and the debate around the death penalty is an important step ahead. And the next step should be precisely as we look at the reality of the right to life in the current conversations that are happening on General Comment 36, we should be thinking about the implications of transparency with respect to the right to life. As we think about another right, human right that is violated by the death penalty, which is the right to be free from torture, cruel, inhuman, and degrading treatment, we should be thinking in reportage and reporting around CAT and around torture, around CID, including under the 13th Protocol of the European Convention on Human Rights and similar other instruments or sentiments at the regional level. We should be thinking about how we expose the question of the death penalty. As we think about UPR spaces, we should be thinking about transparency as one of the things that we require and that we demand of states to include within their obligations on transparency and what they are doing. As we think about the overall conversation on human rights that even national human rights institutions are carrying out and conducting at the domestic level, it is important that the question of how the death penalty is being administered, how it pertains to particular cases, how it pertains to statistics and so on, should be included. And lastly, I would just add that we should also approach it from the standpoint of the criminal justice system itself and be able to say if we can increase transparency and the spotlight on what is happening right through from arrest to the situation of how somebody is treated behind the curtains to the situation of how somebody can end up on death row, should be so transparent that we are able to go into details such as how many people with mental illness are being affected, which in turn is impacting on the commitment that we have made around supporting the human rights of people with disabilities. So at a variety of levels, one could go on. There are many things that states could do to improve transparency in this area.
Thank you very much indeed. I would now like to open the floor to anybody for comments and questions to the co-sponsors and to the panelists. And I'm also crossing our fingers for another attempt to hear poor Mr. Mayor. But Ninad, we're not quite ready yet, are we, for Mr. Mayor? Okay, no, okay. So the floor is open to anybody who would like to put a question to or a comment to anyone. Thank you.
Thank you, Mr. Moderator, and good morning, colleagues. I'm from the Papua New Guinea Mission, and I'm the Deputy Permanent Representative here. Let me firstly acknowledge the Office of the UN High Commissioner for Human Rights and the co-host of this event. Let me also piggyback on the distinguished Permanent Representative of Australia's reference to the Pacific region, where she noted that there are 2 countries who still apply the death penalty. My country is one of them. Papua New Guinea's constitution validates the death penalty under our penal code, and which still remains in force today. The death penalty forms an integral part of the range of penalties in our criminal code that is available to the independent judicial system to decide on its imposition or otherwise. It is only applicable to the most heinous of crimes as a recourse that is available to the courts with competent jurisdiction. Mr. Moderator, let me put some balance in this discussion we are having. Not all countries who apply the death penalty are secretive about providing information on those who are on the death penalty roll. That is a fact. Let me also say this. It is not illegal for the application of the death penalty under international law. That is also a fact. it is the sovereign right of every country to decide, based on the international obligations, what they can do in their country. That sovereign right is recognized under the UN Charter. And in its criminal justice system, there is an issue for sovereign states to decide and not to be forced or influenced by others to make choices for them. Sovereignty is a fundamental pillar upon which the international system revolves, and that needs to be also respected. I'll pause for the moment, but if there is anything else, I'll add to that. Thank you.
Well, thank you very much, and I'm very glad you're in the room. It's good that we don't just, people who are against the death penalty don't just talk to one another. I agree with you that not every country that practices the death penalty does it in a way that evades transparency, and thank you for pointing that out. Does anybody else like to take the floor? Yes, sir.
Thank you very much, Mr. Chair. Thanks a lot to OHCHR and to all involved delegations for organizing this very interesting event.
Could you identify yourself? Sorry.
Yeah, I'm Lucas Heinze from the Swiss mission based in Geneva. And being myself based in Geneva, I seized the opportunity to promote the work that we do in Geneva. And just I would like to remind all delegations and organizations present here today that we adopted very recently during the 36th session of the Human Rights Council resolution on the question of the death penalty under the leadership of a cross-regional core group comprised of Benin, Belgium, Costa Rica, France, Mexico, Moldova, Mongolia, and Switzerland. And we are very happy that all amendments have been rejected and that the resolution has received more votes than 2 years ago, and I think it might be an indicator towards abolition more generally. There's also in this resolution of the Council language on the importance of transparency in the context of the death penalty. And now I come to my question. The representative of FIDH mentioned the importance of civil society movements in specific countries, and now my question is how can the international community, in particular the UN, regional organizations and specific states support these civil society organizations, and how do they use the work that we do at the level of the UN, the resolutions that I mentioned earlier, are they used by these organizations on the ground, and also all the important work generated by treaty bodies, Human Rights Committee, CAT, and other treaty bodies? Thank you very much.
Thank you for your question. I'll ask Tchérina to answer that a little bit later after other people have had Sumi.
Thank you very much. I'm Suvi Seppalainen from the delegation of the European Union, and many thanks to all of you who have organized this important event. So starting, first of all, as you know, the European Union has a very strong and principled position against the death penalty. It's one of the key objectives of our human rights policy. It's a precondition for entry into the European Union. And we are also the largest donor in the fight against death penalty. So our actions in this area range from assistance to prisoners to constitutional reform efforts, training, and raising awareness with campaigns and other efforts. So it's work that we've been involved in for years already, and this gives me an opportunity to say a few words about the newest initiative we have in this field. It was already mentioned by the ambassador of Argentina, so just to add a couple of words to that. The Alliance for Torture-Free Trade is a joint initiative by Argentina, Mongolia, and the European Union, which we launched during the high-level week. And it's a global alliance that aims to stop the trade in goods that are only used for torture or for killing people. And it stems from the idea that these are not like any other products, that they should not be circulating freely on the world markets. And from the European Union's perspective, we've had these laws in our books for 12 years already, and we've seen that they do make a difference. They have already made a difference. These products are now more difficult to obtain. They're more expensive to buy. And this has given us the incentive with our partner countries to launch an initiative to share the know-how we have. And 59 countries have done so. It was a very encouraging start for us. It's something that we only wish will grow from here. Our door is obviously open for any country that wishes to join, and I wanted to thank all of you who have already done so, and also our civil society partners such as Amnesty who've been with us on this journey. And just wanted to finish by saying that we will obviously, as the European Union, heed the call of the Secretary General when he just said that that we need to be together with the United Nations to work on these issues, and that's obviously something we'll continue doing. Thank you.
Thank you very much, Suvi. The floor for others. By the way, I know there are some retention estates in here, and we'd be very interested in hearing from you as well. Thank you. While other people are wondering whether to just, we'll have Tchérina answering the question from the Swiss, and then we'll take the plunge for Mr. Mayor again.
Thank you very much for your questions. With regard to how the UN and other mechanisms can support civil society organizations, if we take the perspective of Africa, for instance, there has been a huge mobilization from civil society organizations on supporting the adoption by the African Union of dedicated treaty on the abolition of the death penalty, which has been developed by the African Commission. The treaty is on the table of the African Union, and for a couple of reasons and political dynamics within the African Union, it has not yet been adopted. The discussions are ongoing. And there is a very important mobilization from civil society organizations on the continent to contribute to that discussions and to ensure that at some point this protocol is being adopted. So again, trying to have strategic alliances and trying to have as many partners as possible mobilizing to support this work of civil society organizations is important. And speaking about the way civil society organizations have been using all the different mechanisms, especially the CAT, UPR process, and so on, it has proven to be very useful in some instances because, once again, it again creates a space for interaction between states and civil society organizations. If we take the UPR process, for instance, NGOs from Botswana have been very much involved into that process and very much involved into trying to put the death penalty debate during the UPR review of Botswana. And thanks to that mobilization, there has been some kind of commitment from Botswana with regard to the application of the death penalty and with regard to the secrecy as well. So Botswana committed to engage into a national debate in this regard. Committed also somehow to inform family members of death row prisoners prior to their executions. So it was very important in the sense that it created a space that actually did not really exist within Botswana for interaction between civil society and the state authorities. So these spaces are very, very important. And of course, there is a need for continuing support because when they go back home, there is usually a lack of implementation of those commitments, of those recommendations by the states.
Thank you. James, you wanted to answer that. But in addition, could I also ask you one other question, which I'm sure is on people's minds a lot? Dealing with Guantanamo and I suppose other cases of terrorism, and in particularly well-known ones, is there not a case, because I'm sure people maintain that there is, for some exceptional circumstance whereby transparency would be less required than in other instances?
Thank you. With regard to an exception for terrorism cases and the need for transparency, in many ways, trials for major world events like the attacks of September 11, 2001 demonstrate why it is so important for these matters to be public. Those events of September 11th affected not just the many people who suffered on that day and in the years immediately afterward, but really changed the course of world events in many ways, including at least 2 major wars and the ongoing U.S. war on terrorism. It demonstrates how transparency is important not solely for the people who are on trial, but for the victim family members who want information about what happened to their loved ones, who want information about the motives of those who are involved, whether the right people are on trial, and also the actions that were taken in their name by governments such as the United States in matters of terrorism. Transparency is important for criminal defendants, but it's even more important for the rest of us. And if I could briefly address the comments of the Swiss mission, because the military commissions at Guantanamo Bay are a hybrid system which involve elements of military and civilian law, they routinely apply elements of international humanitarian law, which is quite unusual in U.S. courts. We, in that court, regularly debate the significance of proclamations of international law from a variety of organizations, from the Committee Against Torture to the ICRC. In fact, on Saturday, I will travel to Guantanamo expecting to debate the question of restrictions on the right to communicate about torture and its impact on the right to complain and the right to truth under the Convention Against Torture. So the point that I wish to make there is that international processes directly translate into courtroom litigation in the military commissions. The last point that I'd like to observe is that in an attempt to generate some level of transparency, the United States has established a process for observers to see these military commissions at Guantanamo Bay. To the best of my knowledge, France is the only country who has ever sent an observer, and we deeply appreciate their observations of the military commission. I know that the Organization for Security and Cooperation in Europe did begin to take steps toward an observer program, but that was not ultimately able to bring that to fruition. So there are steps that the international community can take to increase transparency at Guantanamo Bay. Thank you.
Thank you very much. Nina.
I am delighted to utilize the digital technology in order to be present and participate in this very, very important day organized by the UN High Commissioner on Human Rights on the death penalty, transparency and the death penalty. As president that I have been until today of the International Commission Against the Death Penalty, and all together with all the other very important institutions that are devoted in the struggle against the death penalty, I can tell you that this is precisely what expresses more, perhaps, than any other dimension in the United Nations, this lucid start of the UN Charter, we the peoples. Yes, it's the voice of we the peoples. We the peoples, not the representatives of sometimes not very democratic states or governments. No, we are all the peoples. And particularly, we are not these plutocratic groups of G7, G8 or G20. No, we are the United Nations. And the peoples of the United Nations that say, no, we must never kill. And the right to life is the supreme right that exists. The equal dignity of all human beings. This is fantastic. All human beings are equal in dignity. And to kill them, the state being the killer, never. We must all be in favor of abolition of the death penalty, and of course they must be according what they have done, the crime that they have committed, but not to utilize the execution. I think that this is very good, and also this has not any deterrent effect. And also, and this is very important as well, sometimes what are killed are innocent. Therefore, my dear friends, transparency, yes, transparency can help very much in order to dilucidate and to know exactly where we are in the different countries. In general, the trends are very good. Today, there are more than 100 countries in which the abolition or the trend to abolition and no execution already. And also we have some cases in which the improvement is necessary and must be very rapid. For example, but even in these countries we have good trends. For example, in China, in Iran. And the problem that we must now face is also the United States, when there are still too many states in which there is retentionism, and this must be ended as soon as possible. Dear friends, if we give very good information, if we provide exactly what is happening and what has happened in order to apply exactly from the point of view of justice what they deserve, this is the way by which we can, I am sure, in some years, to tell that the abolition is already worldwide and the justice for those that have committed some crime is never, never related with the death penalty.
Well, we're very grateful to Mr. Mayor for sending that, including his generous remarks about the state of our technology. Would anyone else like to take the floor? Or, by the way, including the panelists, if there's any final word anyone would like to say.
Thank you, Andrew. I think from our point, just again to acknowledge the many acknowledgements of the work that we have been doing. We remain committed to work with you on the transparency part of the journey around the death penalty. And in short, we would say, in the view of Amnesty International, even under existing international law, it is actually not possible to meet the standards of international law without transparency. So not only would it help, but it is actually central and critical. And we also appreciate, of course, the efforts of the various organizations, civil society, lawyers, NGOs, and so on, that are contributing to transparency and information and working with us. And we also appreciate even the efforts that some states are putting in place, sometimes not as acknowledged as they ought to be, such as, for instance, Singapore, which in the last 5 to 6 years has been providing some annual information. So with that, we thank you for the opportunity also to participate here.
No, maybe just briefly to reiterate the thanks to the OHCHR. I really think that again, creating the debate is important. I think this is the ambassador of France who stated that within the current context, there is a temptation to reinstate death penalty in a number of countries, and we have seen that in countries like Chad, for instance, which had abolished the death penalty, but then reinstated it to fight against terrorism. So we believe that this is a permanent debate that needs to take place, even in countries that have abolished the death penalty, and this is very useful. This is a very useful debate that you have created, and there is a need for creating this kind of debate and space for continuing debating on this.
Thank you. Given the issues of due process and error and discrimination which are rife throughout the death penalty process, it's clear that states have a lot to hide when it comes to the death penalty. That problem gets worse when a state chooses to use extraordinary processes without an independent judiciary, which did not comply with customary international law requirements. In those situations, as in many others, transparency is critical to bring the flaws in the process out of the darkness and expose it to examination by the international community. Thank you.
Thanks very much, and thanks again for organising this. I really think it's an important topic, and it's extremely useful if we can engage in discussion. And I'm not sure if my colleague from PNG is still here because he's obscured by the column. Okay, but can I say I also welcome his intervention. I do think it's important that we don't just talk abolitionists to abolitionists, that we do talk to those who also retain the death penalty. And I should acknowledge, because I think it's important, that PNG actually hasn't executed anyone for 60 years, which is 10 more years than in Australia. So maybe we've got a lot to learn as well. So thank you.
Well, thank you very much indeed for that. We've taken very careful note of what everyone has said, and I think we will drop some conclusions and post it on our website. We are very, very grateful to everybody, as I said, the co-sponsors and the panelists for a very good debate, and thank you for coming.